I'm one of the general chairs.
Oh, lovely.
Hi, good to meet you. I'm just making sure that, do we know whether we're all set up for all the AV needs for the room?
We are all good.
Okay, so I'm going to stay. This is of interest to me, but I want to make sure that there's nothing.
No, the staff and Meg have been taking excellent care of us, so
Great.
we are good.
Great. Well, we have had problems. So
Yeah.
in a shocking turn of events of technology.
Shall we make a start, or do you want to wait till?
Are you changing the slides?
No, we don't need slides.
No slides?
No slides.
Shall we start?
Yeah.
Okay. Hi everyone, we're going to get started. I know this is a little bit of an intimidating request, but come closer. We're hoping to have a genuine discussion, which is going to involve passing microphones around, and that'll be a lot easier if folks are closer. Plus, you know, it's been a long conference. It's nice to see people's faces, but we do totally understand if you want to be lingering up the back so that you can sneak out. Come closer, closer. Okay, great, thank you. Thank you so much for coming to this session. It is, we know, basically an afternoon session on day 4 of a 4-day conference, so well done to you brave souls for sticking with it. And want to say a huge thank you to the organisers of the conference, and especially the folks behind the craft track, Meg, Jen and Hannah. It's been really exciting to have the opportunity to attend the craft sessions and be part of a craft session, so thank you. We were keen to just get a bit of a read on who our audience is today. So we're going to ask 3 questions. For show of hands, please, just so that we can get a sense of what the kind of distribution of expertise and backgrounds is. So the first question is about expertise. Your choices will be social science or legal or computer science stroke technologist. So hands up if you come from a social science background. Okay, 2 hands, very good. Hands up if you come from a legal background. 3.5 hands, do I call that? And then hands up if you come from a sort of computer science or data science. Okay, right, mostly, this is very exciting. We are delighted that you came. Thank you for venturing into this space. So then the next question is, what sector are you from? The three choices will be commercial, NGO, or academic. So hands up if you're from a commercial organisation. Sort of 7, 8 hands, very good. Hands up if you're from an NGO organisation. 4 hands. And hands up if you're from an academic institution. Okay, nice. Yeah, good. So that's a almost relatively even spread. Delightful. And our final question, predictably for lawyery types, is what jurisdiction are you from? So there'll be 2 choices from the global minority, and then, like, forgive us, but like the third choice will be global majority. So hands up if you're from, like, if your work is based in the US. I'd say about a third of the audience, give or take. Hands up if your work is based in the EU. Oh, lovely. About a third. Okay, lovely. And then global majority. Anyone based in the global majority? Yeah, half a hand. Very good. Well, welcome all of you, and thank you very much for bearing with us. That just gives us a sense of what we should be assuming and what we should try to not assume. My name is Sweeling Harris. We're going to do this in sort of 2 parts. The first half will be quick presentations, and then we'll move very much into Q&A, and we're hoping to spend most of our time in discussion. So please do be thinking of questions, and those joining us online, please do put your questions in the chat, and we will very much try to include those and not forget you. I work at the philanthropic organisation called Luminate. Luminate is a global philanthropic organisation. We're funded from the personal wealth of Pierre and Pam Amidia. And I am director of litigation there, leading a program of work funding public interest litigation in Europe with a particular focus on the big tech platforms and their impact on our public discourse in terms of mis and disinformation and amplification of hate speech and other toxic content. So I'm going to kick us off with an overview of some recent legal developments in the EU, not in the form of new laws that have been passed, but rather of decisions that have been made by courts and/or regulators. So the first case related to an NGO called None of Your Business, which is run by Max Schrems, and they made a complaint to the Data Protection Authority in Ireland in relation to Meta and the lawful basis for the data processing that Meta does. Meta argued that tracking and online advertising were part of the service and that the lawful basis for the data processing was contract. This was rejected by the European Data Protection Board. I will not go into the intricacies of where the board sits in comparison to local data protection authorities, but let's just say the Irish were, broadly speaking, overruled by the European board. And accordingly, Meta was fined €390 million, which was one of the sort of, I think it's the biggest fine so far that we've had in Europe, and Meta are appealing the decision. So many of you will already know this, but just for those who have not spent time thinking about the general data protection regulation of the EU, all processing of personal data needs a lawful basis. There's a few to choose from, as it were. There's a few options. One of them is contract, one of them is consent, one of them is legitimate interests. Meta was arguing that they were relying on contract here, and that has, at least for now, failed, but we'll see what happens in the appeal. There's a case that Luminate is supporting in the UK, which is brought by a campaigner called Tanya O'Carroll. Some of you may know her. She was one of the founders of Amnesty Tech. She is also in litigation against Facebook, trying to exercise a right that she has under the GDPR called the right to object. And that is a right to object to all data processing of personal data, which is done for the purposes of direct marketing. And so Tanya is trying to exercise that right. Meta is arguing that she cannot exercise the right, or that the right doesn't apply to them. That will be going to a court in England and Wales in the not too distant future. There is a competition law case that is before the Court of Justice of the EU. That's quite interesting because when people think about data processing and personal data processing in Europe, they're generally thinking about the GDPR. Here, the German competition authority made a decision about Meta's data practices being an abuse of dominant market position. So exercising their authority as a competition regulator, but reading across and drawing inspiration from the GDPR, and also from German constitutional rights, on which I very much defer to Thomas, not being a German lawyer myself. That has gone back and forth in the courts in Germany, and it is now sitting before the Court of Justice of the EU to see whether, in fact, the competition authority has competence over it. There's been a similar case in relation to unfair practices and the protection against unfair commercial practices that exists in consumer law. That again went to the Court of Justice of the EU because there was an argument about whether a consumer protection agency, kind of like Consumer Reports in the US, can argue about breaches of the General Data Protection Regulation in the context of consumer protection. So relying on the consumer protection against unfair practices, but reading across to data protection law. And in that case, the court found that indeed it's completely fine for a consumer rights organisation to make arguments about unfair practices and to have standing on that basis, but to look to this other area of law, data protection law. Finally, one of the most interesting cases, perhaps from the perspective of this audience, is a decision by the Belgian Data Protection Authority against IAB, which is the standard-setting authority, standard-setting organisation for the advertising sector. There were a number of NGOs, including Panopticon, at which Kasia leads, challenged the transparency and consent framework that was established by the IAB. So that's the set of standards for cookie banners. And the Belgian Data Protection Authority found that the consent system infringed the data protection law in a number of ways. I won't go through all of them, but importantly, there's a real question about, given the complexity of the ad tech ecosystem and the ways in which data moves to different data brokers and is processed and aggregated and all the rest of it in the ad tech system, what kind of transparency could possibly satisfy the requirement of transparency in the GDPR? Certainly, things as they stand, the amount of information that's being given to users at the moment was found to be not in conformity with the GDPR. So once again, that is being appealed in different ways, and we wait to see what the CJEU will say in relation to a number of specific questions about joint controllership of data and how far that extends. So with that, I'm going to pass to Kasia, and perhaps if you can give an introduction to Panopticon as well as your work, that would be great.
Thank you so much for inviting me to this space. I do regret I can't be there in person, but that's certainly better than not being here. My full name is Katarzyna Szymielewicz, but I go by Kasia, which is certainly easier to pronounce for non-Polish speakers. I'm still based in Warsaw, Poland, and this is where 15 years ago I started my own NGO called Panopticon Foundation. But soon after we started our work on surveillance, human rights, technology in Poland, we joined a European network called European Digital Rights, which is the only way to have influence on Brussels level politics for us is to work as a coalition. So a lot of my work in the last decade has been done on that level. I've been also a vice president of this bigger coalition for more than 7 years. So my perspective is both Polish and Brussels. Brussels is a specific, I mean, I would not say Europe. Brussels is a very specific place to do politics. So I would never dare to say that we have an overview of how Europeans think about certain issues or how European policy is shaped, but I can say something about Brussels. So my perspective on this topic and the overview, you already heard from Sui is that we, as activists, legal activists, we've been trying to find the best angle to stop the business model based on data on exploitation of data and algorithmic management of humans, essentially. Stop it without destroying the source of it, which is surveillance capitalism. We might like to destroy it, but we don't feel we are capable of doing it, and it's any realistic scenario in this decade. So that's why we've been trying to find a more realistic angle to attack the business model at its essence. And therefore, for us, the key aspect that we were trying to uncover, discuss through litigation and advocacy, and hopefully change, is the way data about humans are collected, generated, and used without them being aware, right? So with the privacy debates from 20 years back, people were mostly concerned about my data not leaking somewhere else, or somebody who I have not authorized not uncovering my secrets. Last decade for us is a very different debate. We are trying to divert attention of courts and regulators from this old notion of privacy associated with hiding something or protecting your information from being revealed, to what really happens, what really matters, which is generation of information about humans without them controlling it at all. What I mean here is mainly the hidden work of algorithms behind, all social media, advertising, essentially all internet platforms have that feature that people not only are being observed based on what they share, but above everything, they are being observed based on their behavior. And key information, key data used against us, and maybe I will get to what against us means for me, does not come even from observing me, but comes from detecting patterns in human behavior that can be applied to myself as a representative of specific profile or specific group of people. That group can be very small, very tiny, sharing very few characteristics, but it's usually about groups, right? It's never about me as individual. It's usually about me belonging to a certain category that can be targeted. Targeted means against. For me, the mere fact that we are being treated as targets, that it's all about targeting, it's all about offering me something I haven't asked for and hiding this as personalization. This is another core element of this business model we want to attack. So, how you do it if you can't question the very source of it, which is surveillance capitalism. So what we've done, we've done some of the cases that we already mentioned. I think I'm mostly proud of this litigation against AIB/Google, because in this litigation, we uncovered, together with many other players in this litigation, obviously we are just one of the players, but together we uncovered the real machinery that is responsible for this effect I described. It's not one entity, it's not one service, it's not about one website. It is about the standard setters and how these standards operate, and how these standards actually force everybody to play by the rules that benefit very few, that only benefit the intermediaries. So in this case, maybe for the first time, we were talking about the essence of the problem, which is the model, which is the standard, which is how things are being designed, and not so much the behavior or a behavior of a specific company in a specific period of time. But yeah, as you might have heard, this case is still rolling. We thought we have won it. Actually, we've got the very decision we wanted from Belgium DPA, Data Protection Authority. But obviously, our opponents in the case appealed, and it's now in the court that asked questions to the European. To the highest court in the EU, European Court of Justice, that hopefully will give interpretation of the law that is in line with our interpretation of the law. So essentially, we hope the highest possible court in the EU will now say that there is no way to make this model, this business model behind targeted advertising legitimate with consent. There's just no way people can express consent in the situation in which the information asymmetry and the general awareness of people online is not sufficient to comprehend what's going on. But even if it was, you can't possibly agree on the data processing that nobody controls. It's just going beyond anybody's control. And is causing real harm because people are targeted based on very, very sensitive characteristics, based on their vulnerabilities, and they can't effectively opt out. So we're trying to question the whole system. And I think this is the only way we were able to fight it before DSA. DSA, the Digital Services Act, very recently adopted regulation focusing on large online platforms, is a big opening for us, and possibly also a start of new tactics that go beyond litigation, that go beyond standard advocacy, in which we fight for new regulations and then we look how they're applied, and then we complain again that they are not being applied in a radical way, like GDPR. And, over and over with litigation, with complaining, we move on to the next law. With Digital Services Act, we hope for a different scenario. And this is what we are planning this year, how to maneuver in this new reality. Because in this law, European Commission becomes new type of regulator that can do much more than just issue fines or impose a decision that says stop doing what you are doing. The European Commission, under this new regulation, can almost redesign these systems that do targeted advertising, that do targeted recommending to people in the same abusive way, systems that are based on behavioral observation and the analytics behind that. So finally, we have a situation in which large companies will be obliged to self-assess risks related to how their services work. And these risks include fundamental rights, but also civic discourse, electoral processes, environment, so other values than not just narrowly understood human rights. So the self-assessment will come from the large platforms, but then the independent auditing will come next. And finally, the Commission will be looking at all that and hopefully deciding in a pretty radical way, that's what we hope for, how these risks should be mitigated. Mitigation of the risk can include, as I said, redesigning of the system. So we can imagine the Commission going as far as to tell the platforms, you have to change how your algorithm works, or you have to give up on this model of doing advertising because it cannot be reconciled with fundamental rights. You have to find another way, maybe contextual, maybe something else, but just stop doing this model. I know it sounds like a fantasy, sounds like something that does not happen in politics, in real politics, but still, before we see it fails, we will not predict failure. We are pretty optimistic as a movement that has been fighting for this law, that with risk assessments we can achieve much more than we were able to achieve previously with litigation based on old, much less flexible laws. So this is where we are now, and this is where we are reaching out to technologists, to people who are working with algorithmic accountability, who are working with user experience design, to analyze what's not working well on large platforms, but also imagine how things could work much better if we have these mitigation measures. And I'm happy to talk more about things we imagine, things we want to test, but I think that's enough for an intro.
Awesome, thanks so much. I'm Thomas Strines. Thanks to Svilang and Kasia for giving us this amazing overview over recent developments. And I think one lesson that you can draw from their experiences is that law, just because it's there, doesn't do anything. It always needs someone who does something with it. And that can be a corporation that uses the law to shield itself against accountability. But it can also be NGOs that bring strategic litigation, NGOs that force the Commission to do the right thing when drafting the AI Act or when implementing it. And I think that's a very important lesson, especially for this kind of interdisciplinary community here at FACT. I'm based at NYU, so I was at one of the early FACT conferences right there, and it's great to see how this community, this research agenda has grown over time. My name is Thomas Strines. I come originally from Germany, and I used to be a very formalist, doctrinalist European lawyer, as European German lawyers in particular tend to be. But I've been in the US now for so long that I've become more and more Americanized, so much so that someone recently at CPDP, the big privacy conference in Brussels, thought I was American, which I'm not. But the American way of thinking, I think, holds valuable lessons about what law is and what law can do, and whether law is a force for good in society or something that can entrench systemic racism or systemic discrimination in society. So the insights from a more realist tradition that draws attention towards critical legal studies or the law and political economy movement that is resurgent in the United States, I think tells us a lot about what law is and what law can do. Now, if you look at the world of global technology regulation, there's a lot happening in Brussels, and we deliberately structured this session around European legal accountability because there is so much litigation and regulatory enforcement action happening, and as Kasia mentioned, new regulation is on its way, and that regulation is only going to change the platform economy for the better if the law is being used in the right way. So I want to talk a bit about that, but it's not to say that Europe is the only place in the world in which interesting things are happening. There's an interesting regulatory agenda in China that is not exclusively about digital authoritarianism. And the FTC in the United States also is trying to do what it can with the authorities it has. But what we can see is that there are distinct political economies, which doesn't mean that what happens in one jurisdiction does not affect others. So I want to talk a bit about what scholars of regulatory theory would call the Brussels effect. Who has heard of the Brussels effect? Oh, wow. Kudos to Anu Bradford, who coined that term, my colleague at Columbia Law School. So for those of you who haven't heard of it, it's a theory that tries to explain why sometimes companies choose to implement European law even if they don't have to. So if you want to operate in the European market under GDPR and under all these new laws that the European Commission has put forward and that the Parliament and Council have adopted, you need to comply with European law even if you're not based in the EU, as long as you are present in the EU by way of your goods and services or by way of engaging in surveillance capitalism by monitoring the behavior of European data subjects. And for companies, it might make sense to recoup that investment in compliance in Europe by scaling the approach that they have developed to comply with European law globally. So that's what's known as the de facto Brussels effect, that a company decides, based on a cost-benefit analysis, that might get informed by computer scientists, which will say, how expensive is this going to be to re-engineer our systems in a certain way, to then say, well, let's just use that infrastructure globally. But it's important to realize that that's not always going to happen. So a lot of the new legislation that is coming out, like the Digital Services Act, poses the question to companies whether they want to comply with European Union law only in Europe or also outside Europe. And that's a question that also presents itself whenever the lengthy processes that Sri Lanka described through strategic litigation have found a resolution. Whether you try to minimize the regulatory impact by keeping it within Europe, thereby segmenting your product into a European product and a global version, or whether you scale the European approach globally. And that's also where NGOs outside Europe can play a constructive role by pushing companies towards adopting the solutions that the European regulator forces them to adopt for Europe globally. So that's, I think, an interesting element of a global political economy in which different regulatory systems interact in interesting ways. And it's not just a legal story, and it's never just a legal story. So if you follow the Brussels effect literature, it talks a lot about the adoption of legal instruments by companies or by jurisdictions that use European law as a template for their own jurisdictions. But European law also affects standard setting. So the AI Act is going to have a huge impact on the standard setting ecosystem, as new standards are going to get developed to enable the kind of conformity assessment that the AI Act wants to engineer. And whenever a company designs its product or redesigns it, as Kasia described, there's this question of how the law gets integrated into the infrastructure that companies provide. And in that way, for computer scientists, it's a really interesting question to what extent European law is going to be a global standard, and to what extent it's not going to be a global standard because there's going to be segmentation, which is separate from the question whether it's a good idea for European law to be a global standard or not. And I think that's an important conversation to have. The other point I wanted to make is also using the Brussels effect framework, but from a different perspective, from our perspective as researchers in this space. So the Brussels effect is a theory of regulatory competition. It's a theory of corporate behavior. How do companies think about regulation in different jurisdictions? But what does the EU do for us? What can we get out of European regulation? And there, the Digital Services Act in particular is a really interesting provision. So one provision is about access to data for researchers, which has been a tremendous problem in this space to conduct research that would provide meaningful accountability through the scientific community. And the Digital Services Act says that vetted researchers should get access to data from very large online platforms. So those are the biggest providers of social media platforms in particular, to study the systemic risks that these platforms create in Europe. That's how the provision is framed. And it emphasizes it's about the study of systemic risks in Europe. But that doesn't mean that you have to be a European researcher to request access to data. And it also doesn't mean that you can only request data that pertains to Europe. That's the debate that's happening right now as this provision is getting translated into what's called a delegated implementing act. What are the precise rules that researchers need to comply with to get access to that data? And it's a really important question for the global research community to be able to get access to data without which meaningful accountability is not going to be possible. So in that way, I want to close by saying that there's a really interesting way in which European law interacts with platform regulation, technology regulation globally, but there's also an interesting way in which law interacts with what all of us are doing, whether we are at NGOs, whether we are in the academy, or whether we are at companies. And I'm sometimes struck when I have conversations here, particularly with the non-lawyers, how the view of law tends to be one where the law is a separate domain. But it's not. It's always there in some form. And I would be the first to admit that it's often not accessible to non-lawyers, particularly European Union law, which has its own political economy, its own way of expressing things. But I very firmly believe that it can be rendered accessible, and it needs to be rendered accessible to get those involved who can bring the law to life in their research, in their litigation, and in their advocacy work. And that's why I'm excited to be here, and I look forward to the discussion with all of you. Thanks a lot.
So, those with questions, please, I guess, come to the microphone, or if you sort of want to wave your hand, we can bring one of these microphones over to you. While you're thinking of your questions, and please do ask them, no question is too small or too big. We will take them all. I wanted to ask Kasia, so one of the things that I'm really excited about in terms of us, the three of us being here with you, is the opportunity to have an interdisciplinary, multidisciplinary conversation. So as three people with legal backgrounds, I wanted to know, Kasia, you've got a room with quite a few computer science, data science folks in it. What would you like to say to them while you have their attention?
Sorry. Many things indeed. Probably my key message for today is that we lawyers, even if we are ignorant about technology, we are trying our best to improve the way it works, and not only by fighting for new regulations, but hopefully, as we hopefully just explained, by helping regulators and courts understand and apply this law. So the better we understand technology, the more insights we have, the better our work outside there is. So you can think of us as translators or transmission belts between your world and Brussels level politics or courts, which would be a bit far-reached to expect that technologies go there. I mean, obviously we have hearings. There are moments where people like yourselves are requested to come and testify, not only in the US Senate, but also in the European Parliament. It happens. But on a day-to-day basis, if you want to have impact on how digital politics, how policy around technology and how implementation of the law in this area works, you need us and we need you. I already gave one example of how in which space we now deeply, if not desperately, need tech expertise. These are risk assessments. Let me tell you more specifically what could be very useful these days. So we are in the moment where European Commission is preparing for this new role of this super regulator with the possibility of almost like shaping the technology with their own hands. And in the same time, very large online platforms regulated by this law are preparing their own risk assessment, which are due very soon. By September, they're supposed to give something like this to the Commission. And the large platforms are also supposed to come with their own mitigation measures, which is responses, changes to the problems they identified. Everybody in our bubble predicts that we won't get, very clever responses to the problems that have been discussed in the media last decade. We do not expect that these risk assessments will be full of shocking revelations and very radical measures mitigating this named risks, rather not. So how can we prepare? One of the ideas we are rolling these days is that we NGOs, we activists, with the help of researchers and technologists, come with very specific questions, or if you like, hypotheses that summarize the state of research on what types of harms are caused by various elements of online platforms, including recommender systems, advertising systems, how they moderate content or don't moderate, how they shape interfaces with dark patterns and all that. So we can take key elements of the systems that will be assessed, that should be assessed, and create our own questions that include a thesis or clearly a list of strong hypotheses based on research whenever we can build a correlation between, or causality even better, between specific feature of the system and specific harm to humans or our environment. A list like that will be stronger if we back it up with some form of evidence, and even stronger if we come with our own matrix or ideas how to measure these effects or how to verify how these effects can be verified when you are inside of the platform. So, for example, one of the typically observed harms in recommender systems is a situation in which people see much more borderline content, much more content that is objectively harmful and close to what platforms themselves usually think that is against terms and conditions. That's why we call it borderline, because a minute later it's moderated already. It disappears from the platform because it crossed the line. But before that line gets crossed, content is there, and it's very often harmful content, harmful in various ways, because it leads to disinformation, because it spreads conspiracy theories, because it's simply very low quality, it's sensationalist, it's abusive, for a number of reasons, we can call it borderline. So we have a lot of evidence showing that amplification of this type of content clearly happens, and we get this recommended much more often than we should see it if it was just a statistical thing, like no amplification involved. Why that happens? There are at least two choices in the design of recommender system that probably are the cause. One is engagement-based logic of the recommender system itself. So the decision of a commercial platform to prioritize engagement above any other metric of success, and to design, to choose variables or whatever they have inside, better than me, that have impact on what gets recommended based on engagement as preferred result. So that's one feature or functionality of the system that we can describe in much more sophisticated way, including formulas and the language of statistics, which I can't use, but probably many of you can. The other choice is in moderation, in content moderation, that is also done by algorithms, at least in the first stage. We know that platforms usually give preference to when they need to go for when they need to do a trade-off between precision and accuracy, they are more likely to prefer false negatives rather than false positives, because at the end of the day, they simply prefer more content to be available, right? So when tweaking their content moderation algorithm, they will punish the false positives, but not the false negatives. So that's another choice related to business goals behind the whole thing that has this negative impact on society, because we see more borderline content. So I only gave you two examples of the sort of hypothesis we want to formulate and give it to the Commission, with the expectation that the Commission will help us validate them. And again, I mean, the deeper we go in this understanding of how, in this case, algorithms work, but also other elements of the system are relevant here, probably the better responses at some point we can get from European Commission or other bodies involved in DSA enforcement. So this is where we are looking for expertise, and this is where I'm always really keen to start a conversation, and regrettably I can't do it right now after the session, but there will be ways of reaching us for all of you who want to somehow get involved in this work.
Absolutely. Feel free to contact me in person here, and I can connect you with Kasia, who's very kindly joining us from Poland, where it is late. So thank you very much for joining us at this late hour. We have questions. Please come up to the mic and ask.
Hi, I'm Maike Tillicke. I'm based in Berlin. And since you were saying that you don't have to be a vetted researcher in Europe, I would love to hear more, because I already know a bit about this thing that is coming up, that you get access to the data and stuff. But I'm wondering, how would it work if, for example, I'm in Germany and then I want to collaborate with people from the NYU? Will the people from NYU have access to the data? What sort of questions will we be allowed to ask? Could it be US versus EU something? And this sort of stuff. And the second question that I have is a bit more general, and feel free to just skip it, but I'm wondering, how can we make sure that, the law that is passed and that it is informed by experts that come from this community and other communities, and not, random CEOs showing up and then getting appointments with Ursula von der Leyen? Yeah, so I don't know if this is something you could answer.
Thanks. And I suspect for the next, adjust the mic was my request, but good. Thomas, do you want to?
Yeah, sure. Thanks a lot for the question. So I've worked a little bit on the vetted researcher question with the Data Co-ops project that Katrina Liggett, Kobini Seaman, and others that try to build on differential privacy analysis to develop different kinds of data governance systems. And to do that well and to see how that would fare in the platform economy for those researchers would be really useful to get access to the data, but they're based in Israel and the United States. So the question arises whether the DSA would grant them access to data or not. And that's a debate, and what I gave you is my strongly held view that we also put into the consultation, but it's also the view that other DSA researchers hold, because there's nothing in the DSA that says you have to be a European researcher, and European law can reach beyond Europe's borders. And there's no reason to think that if the goal is to create a safer online environment, as Kasia described, why only European researchers should be able to get access to data to provide research that would create a safer online environment in Europe. If I'm wrong, you could still get around it. And I think that's why it's so important to learn how to think like a corporate lawyer. Because if you're a corporate lawyer and there's a law that only applies in a given jurisdiction, what you will try to do is to get into that jurisdiction. So you just incorporate there. So if I'm wrong and you have to be a European researcher, you could still partner with a European researcher, or you could try to become a European researcher to get access to the data, to conduct this kind of analysis. And you gave us one strong argument why it's desirable to not just get European data, which is we want to be able to see whether the responses to, for example, the risk mitigation that platforms are required to conduct, where they actually work. And the only way one way of doing that is to compare the implementation of the Digital Services Act in Europe to the non-implementation of the Digital Services Act elsewhere. And to do that, we would need to get access to non-European data, which is why there's now a push by researchers like Martin Huseweg, who's also worked a lot on that to enable that. The other point you raised, I couldn't agree more, but one thing that's good about lawmaking is that Ursula von der Leyen is a really important figure in the European political economy as president of the European Commission. It carries a lot of political weight, and without her support, we wouldn't have seen the regulatory agenda that the European Commission has put forward, but she's not drafting the law. The people who draft the law are much more low-level people, and there it is a problem that they are craving input. And of course they get a lot of input from interested stakeholders, and they don't get enough input, and I think often struggle to find ways to integrate the research input. And I think that's often a question of access, it's a question of translating research findings into language that a lawyer understands, that a policymaker understands, but I think that work is so crucial to counter the high-level claims that we get from other interested stakeholders that try to influence the European law and policymaking process.
And on a practical level, I would just make a call for transatlantic relationships to be strengthened and interdisciplinary relationships to be strengthened, because I mean, Kasia and Panopticon are very much a part of a really vibrant network of NGOs called People versus Big Tech, which did a lot of advocacy in relation to the Digital Services Act. And the more civil society are talking to each other and folks focused on the public interest are talking to each other, the stronger we can be. Shall we move on to the next question? Go for it.
Yes, thanks. Hi, I'm Rishabh, engineer. My question was a question about how you see GDPR affecting language models. So my understanding is like ChatGPT was banned in Italy partly because GDPR restricted training. There was not consent for the training data being collected from users. And my understanding, without having any inside info, is that same was happening with Google Bard in EU as a whole. And also my understanding is like people, like CEOs on Twitter aren't super receptive to this and are expecting GDPR to change. And I'm wondering what, or at least like being not implemented in this way. I'm wondering what you see as the future of that. Yeah.
I would speculate that if the recent history of challenges to ad tech and other large platform data processing is anything to go by, there is no prospect in the near term of GDPR either being changed or not applied. And in the event that regulators were to fail to uphold it, civil society will very much be stepping into the gap to raise legal questions in the way we've already discussed. And with that said, I saw a story yesterday, I think, that the DPC, the Irish Data Protection Authority, has put a hold on Google's AI being rolled out in Europe based on the data protection regulation. So I would anticipate from a legal perspective that it's going to bite and it's going to make a difference, but I don't know if from a political economy perspective you've got a different...
Yeah, but let's hear from Kasia too. I have a political economy take on this, but I'm also curious what Kasia thinks.
If I got the question right, and whether the angle of the question goes towards, will GDPR be changed because it's not easy to apply it to LLMs, then my answer is probably not, because it's not the first failure of GDPR enforcement, right? We've been discussing a few of them in Sui Leng intro. You've heard some, and I can speak more to this. So putting it very bluntly, GDPR is an ideal standard that EU would like to see, but in so many aspects of how technology works, we were not able to uphold this standard, that this most recent failure to correct the market is probably the least of our problems. And yeah, maybe it may sound bold to you, but in my humble opinion, we have much bigger problems with GDPR, even not applied to sophisticated technology, but simply to how education, healthcare, and bureaucracy in Europe work, because it's really difficult to live up to this level of responsibility for data, including risk assessments and a cycle of redesigning systems to make them, secure, to live up to the principle of privacy by design and default. This is all pretty hard. So we are failing in so many aspects that LLMs are actually not a big deal when it comes to training, because indeed it would be very difficult for me as a lawyer to imagine any sensible application of GDPR here. You can't possibly clean database like this of sensitive data, sensitive characteristics, where GDPR formally requires informed consent to do whatever with it. So that's first impossible thing to achieve or demand. And it's not only difficult in application, it's also difficult to define the real goal of application, of applying GDPR to training large language models. What's the harm really of when algorithm like that gets trained on human data, including personal data? Is harm in the training itself, or are we talking about harms when these models are applied and when these models create outputs that are potentially infringing data protection law or copyright law or whatever else they can infringe. So my take on this is let's rather look at outputs and functioning of these models and the context in which they are used. And this is what we can do with the new regulation actually voted yesterday in the European Parliament. So it's on the way, the AI regulation that includes the whole chapter on what it calls fundamental models. And this is where we can tackle what I believe really needs to be tackled here without this, being super careful about the choice of training data. Okay, maybe let me also clarify this. The choice of training data, the quality is super important. And let's look at that. But the legality, whether we can clear the database, this is another thing. And maybe I will be criticized for this bold statement, but I don't really think it should be a big problem when it comes to protecting our data because we have so many bigger ones.
Yeah, you see, that's a quite pragmatic take. So I think it's such an interesting question because I think it tells us a lot about GDPR and what it is and what it does. And it captures so much of the imagination of researchers, policymakers, regulators, and litigators. But there is not the GDPR that means one thing, and everyone agrees what it means. There are some who think that GDPR enables surveillance capitalism because it's too easy to ignore it, or it's too easy to comply. It's too easy to just have a contract, which is why it's important to push back against contracting as a legal basis for all kinds of data processing. Or it's too easy to get consent based on this transparency and consent framework, which is why the IAB Europe litigation that Kasia has been so involved in is so genius, because it tries to turn GDPR into an infrastructural law that changes the infrastructure of surveillance capitalism, targeted advertising, by way of affecting the standard that scales, that different entities are going to rely on. And that's a big debate within tech regulation more broadly, but with regard to GDPR in particular, what is it? What can it do? And what can it not do? And I think I agree with Kasia, and I think what we see here is how the reality in which we all live, whether we like it or not, has moved away a lot from what GDPR imagined a data set would look like and what a data transfer would look like. In 1970, a data transfer was me sitting in a car and driving from Germany to France. That's not the kind of data transfers that Facebook is interested in. And when OpenAI developed its large language model, they clearly didn't care about GDPR, because if they had cared, they would have established themselves in Ireland to have to deal with the Irish Data Protection Commission under the choose your regulator system that GDPR enabled. But that doesn't mean that we should necessarily insist on the ideas that have animated GDPR with regard to large language models. And that's, I think, one reason why the Italian Data Protection Authority reversed course, ultimately, and came to an arrangement with OpenAI that says, well, maybe we can use legitimate interests here. But there are lots of NGOs who think that's a problem, because then maybe legitimate interest as a basis for processing of personal data will also be used in other contexts. There's some who think targeted advertising is a great thing, and maybe we should have a legitimate interest in targeted advertising. So that's why it's always a fight, and it's about who has the better arguments and who has the better scientific evidence. And the other political economy element is back to the enforcement infrastructure of GDPR. Why the Italians? So the French Data Protection Authority immediately followed suit and said, well, we have been working on this for a long time as well. Now the Irish Data Protection Commission gets into the action as well. And there are elements of GDPR that might be relevant for large language model implementation in particular. So the most recent decision with regard to Google is about data protection impact assessment. And that's maybe not a bad idea, because it's more it's asking the kinds of questions that Kasia asked, like what's the effect of rolling out a model in a certain way. And that's where GDPR can have an impact. But of course, a lot of the conversation is going to shift towards the AI Act once we know what it's ultimately going to look like.
Thanks.
Hey, so this is a very typical American question, which is, what does this mean for us? So I work on tech and abortion. Folks may have heard we had some changes in our laws here. And so now we're really worried about like data continuing to live on, and like the half-life of data, and especially like the subpoenability of data. the storage of data and all of that. And so I'm curious, like, if you think there's any impact of current European laws, maybe some of the Brussels aspect that we can look forward to, or maybe that we should be aware of in the coming near future.
Kasia, I don't know if you've turned your mind. No.
No, I am afraid I can't say.
I mean, the observation that I would make is, I suppose I would say this, wouldn't I? It's a shame that there isn't a GDPR kind of law here. One of the principles of GDPR, imperfectly realized, but it is there in law, is data minimization and not collecting data unnecessarily. And I mean, I wish that was an enforceable right for folks here. We will run a little bit over time. Thank you.
Yeah. So just briefly on your question, I think it's really important to realize that there's a different baseline in the United States because there is no comprehensive horizontal data protection law, and it affects all kinds of sensitive areas, including policing. Barry Friedman at NYU runs a whole project that tries to come up with a different data governance framework that constrains police ability to just buy data or get data anywhere. And in the health space, there is HIPAA in the United States, but that's also such an imperfect law. Salome Viljoen is doing a lot of good work on that, trying to show that there are all these apps that have all kinds of sensitive data, including the data that you're concerned about with regard to subpoenability, and they're just not covered by HIPAA because they're not healthcare providers. So, and I think there's a general lesson here about when we design laws, how to design them in the way that they actually protect what we care about. Unfortunately, as you know better than, or as everyone knows in the United States, it's very difficult to pause anything. There has been activity at the state level, and the Brussels effect in that regard often plays out as a kind of template move that ideas come across the Atlantic, and that's also where the transatlantic NGO network can play a meaningful role to get ideas into the US political discourse. But as someone who has been in the US now for a couple of years will be the first to admit that it's an uphill battle for sure.
I'm conscious of time, so how about we sort of take the questions like as a cluster, and then we'll try to actually get to all of them in responses.
Okay,
Go for it.
I have two, but I'll try to be short. And I don't belong, I represent the category of others relative to the disciplinary partition. So the first question, and sorry for my ignorance, as I'm not a lawyer, is it possible that the GDPR comes in the way of actually the Digital Service Act, in the sense that we need researchers to use data, and so what's it gonna be? Is it gonna be anonymized data, or is it gonna be personal data with the ground of scientific research, or what? I mean, has this been thought about? And the second question is systemic risk. So what the hell is that? Is it just a collection of different empirical indicators or drivers of risk? What about the fact that society is complex, and for instance, just thinking about the example we had before of the true negative or true positive, the speaker was thinking about harm. And of course, if you want to reduce certain types of harm, you should actually be more worried about the false negative. But on the other hand, that creates the other problem of giving so much power to the platform to decide, for instance, what is the shape of freedom of expression, which is also a terrible perspective, and we know these two things are one against the other. So how are we thinking in terms of systemic risk about this thing? Is it the composition of these contradictory sources of risk, and who is going to say how this should be balanced? Thank you.
Hi, thank you so much. Matt O'Shaughnessy, I work at the Carnegie Endowment. My question is, Thomas, you made such an interesting point about law alone not being sufficient to create change. And I was curious if you could maybe draw some lessons from the strength and also limitations of Europe's enforcement bodies, civil society. and lessons for other jurisdictions that are thinking about passing copycat laws or laws inspired by them, maybe countries in the global south that don't have as much capacity. What kinds of things should they be thinking about when they're considering trying to replicate things?
Hi, mine is more a comment rather than a question. I work for the European Commission. I work at the European Center of Algorithmic Transparency. So I wanted to thank you a lot for this. Hi. Yes, and I wanted to say let's stay in touch because it's really exciting to see that, because everybody in this community is talking about the AI Act, which is super important, but I think the real game changer will be the DSA. So also, I was super happy also to hear Kasia that she's already, working on defining, all the possible questions. So let's stay in touch for sure. By the way, I will be in Poland, in Warsaw, at the end of the month. So by chance, we can meet. And so, yeah, I just wanted to say thank you very much for bringing this topic up. And also, the team is growing, so we have 2 vacancies right now for the investigative